Lords, I appear on behalf of the Revenue.
Yes, I thought the case was going to be called on, but
apologies.
I don't. There's a,
Appeal in the matter of the Commissioners for His Majesty's Revenue and Customs and Wilkes.
Mr. Yates.
My Lords, I appear on behalf of the Revenue with Laura Poots, who represented HMRC before the Upper Tribunal. My learned friends Richard Villat, King's Counsel, and Marika Lemos appear on behalf of Mr. Wilkes pro bono. This appeal concerns the question of whether the Revenue have a discovery assessment power in relation to what is called high income child benefit charge, or as I wish to call it, HICBIC, by way of acronym, in circumstances where the taxpayer has not filed a self-assessment return. And by brief introduction, I want to just turn immediately to Section 29, which is the provision in question. You can find that in Authorities Bundle 1, Tab 1, page 29. And you can see there, Section 29.1 has three subsections. We're concerned with A. If an officer of the board or the board discover that, as regards any person, the taxpayer, at a year of assessment, that any income, ... which ought to have been assessed to income tax, or chargeable gains which ought to have been assessed to capital gains tax, have not been assessed. It then goes on to say the officer may make an assessment in the amount, or the further amount, which ought, in his or their opinion, be charged in order to make good to the Crown the loss of tax. And the issue which arises in this case and several others is, as found by the Upper Tribunal below at least, that where a taxpayer has not filed a self-assessment, the wording within subsection A is not wide enough to cover HICBIC because, on the reasoning of the Upper Tribunal, it is not income, but rather is a charge to income tax. By contrast, there would be no issue for a taxpayer who had filed a return but had not accounted for HICBIC, because then the revenue could go under item B. And that is the issue in a nutshell. There are three arguments which go towards that. The first is the purposive argument. So can you read income more widely, such as to cover an amount chargeable to income tax? The second is what I think both parties are going to term the Wiseman argument, which is an argument first developed by the FTT in a case called Wiseman. And the third is the Inco-Europe argument, which is essentially inviting this court to rectify not Section 29.1a directly, but rather when HICBIC came in Finance Act 2012 and amended other parts of the TMA, in particular Section 7, the Revenue say it slipped and forgot to make a similar amendment.
To which section specifically are you going to invite us to amend under? Inco, when you get there.
It's under paragraph 2 of Schedule 1 to the Finance Act 2012, which should have made an amendment to Section 29.1a, if you follow me. Just by way of background, you've probably seen reference to this in the Mr. Wilkes' skeleton argument. At the time of writing the skeletons, there was a drafting in the Finance Bill which sought to resolve this problem. And that has now become law in identical terms to the draft legislation. The draft legislation is found in AB 2, tab 35, and I think we might as well just go to that now again, just to deliver some context. And that's at page 624 of the bundle. So this is obviously the draft legislation. As far as I can see, it's in identical terms in Section 97 of the Finance Act 2012. And you can see that the amendment which has now been made under sub 1.
So that in effect adopts your purpose of construction of section 29.1.
It does.
And just help me, subclause 2, that affects, in effect, a further change to section 29.1.
Well, if I may just describe what this does. Over time, there have been a patchwork of other assessing powers, which has been mentioned in the upper tribunal decision below. And for example, Regulation 9 of those regulations gave a freestanding power. Well, I'll rephrase that. It sought to amend section 29.1a purely for companies within 3 cases mentioned in that regulation. I will take you to that regulation. But essentially, this amendment makes that now unnecessary, so that's why that gets repealed. The other important feature of this amendment is it is in fact retrospective, save for
What, the subsection 1
yes,
amendment?
it is retrospective, but it does not affect anyone who essentially raised the points which are in this appeal before June 2021. So it is retrospective, save for, retrospective for 4 categories of tax, which you can see set out in subparagraph 4. So HICPIC, gift aid, and then 2 provisions relating to pensions. But that retrospectivity is then disapplied if someone has already got their appeal in, as it were. So this legislation does not affect this appeal or the cohort of individuals, I think just shy of 400, who are similarly affected. But otherwise it's going to do the job both prospectively and retrospectively. Before I jump into the main submission, there's just one other point, which I think I just need to raise by way of housekeeping. I don't think there's anything in it. You would have seen in the respondent's notice there was a complaint about the notice of appeal not being served in time. There was then an application which was made with a witness statement and draft order, which went in some time ago, last year, which was then chased up on by the solicitor's office. I think there was an email reply from the Court of Appeal office saying we don't normally deal with retrospective orders for service of the notice of appeal on the respondent. But it technically hasn't been resolved, that application.
Let me see if Mr. Vallet has anything to say about it.
No, we're here now.
Yes. Thank you.
The confusion, just by way of very brief background, was whether the revenue had to serve the sealed order or whether an unsealed order would have been good enough, because the revenue didn't get the sealed order within 7 days. That's really the gist of the complaint. Very good. Well, with that in mind, I propose then to start the main body of my submissions with a description of HICPIC. And with that in mind, can we just turn to Authorities Bundle 1 and tab 5. And you can see that new sections into the Income Tax, Earnings and Pensions Act 2003 were inserted by Finance Act 2012. And that provides for a charge to income tax for a tax year if P, i.e. the taxpayer's net income for the year exceeds £50,000, and then you have to meet either conditions A or B, or indeed both. Condition A is that the taxpayer themselves receives the child benefit, and no other person who is a partner of P, that is either a spouse or someone who lives with the taxpayer as if they were husband and wife, has adjusted net income which exceeds that of the taxpayer. So the person who pays the HICPIC has to be the higher of the two. So if both of them exceed the threshold, for example, it will be the one with the highest income. Condition B is that someone else, other than the taxpayer, is entitled to an amount in respect of child benefit. And they are a partner. And again, the taxpayer has to have the higher adjusted net income.
Partner throughout the week.
Yes, well, it is on a week-by-week basis, but in practical terms, it is for most people at least. They're simply charged on the year. There are other there are provisions dealing with the week, and there are also other provisions dealing with situations where the child isn't actually living with the benefit claimant. But I don't think we have to get into that.
Right.
All permutations of
those family law aspects don't arise on this appeal.
No, but all permutations of modern family life are essentially
Fine.
thought to be catered for in the drafting of this. So if we then turn over to page 80, you can see the amount of the charge. And the amount of the HICPIC for which a taxpayer is liable is the appropriate percentage of the amounts in relation to which condition A is met and any amounts in relation to which condition B is met. And essentially the way the charge works, and this is described by the upper tribunal at paragraph 15, and it's actually a point also made in the explanatory notes when this was introduced, is for every £100 your income exceeds, or the person with the highest income exceeds £50,000, that adds on a percentage. So that by the time you reach £60,000, the full amount of the child benefit is essentially charged by an equivalent amount of tax. So the benefit of the child benefit is essentially reversed out entirely once one partner's income exceeds £60,000. And I suppose the only other, just by way of a whistle-stop tour, if we turn to page 86, you can see the meaning of partner there defined, and in particular for unmarried or people who aren't in a civil partnership, you're treated as partners if you were living together, if you were a married couple or civil partners. And then again over the page at 87, you can see adjusted net income is defined, and also week, picking up on my lord's point.
Yeah.
And then, just to see what adjusted net income is, if we turn then to tab 7, we can find the provisions of the Income Tax Act. And if we turn to page 198 of the bundle, we find the meaning of adjusted net income. And the calculation of that. And for adjusted net income, you need to, first of all, find what the individual's net income is. And for that, one has to jump to section 23, which is found on page 175 of the bundle. And you'll see just above the second hole punch there, under step 2, the sum of the components reached under step 2 is net income. So that's the HICPIC charge. So it goes without saying, because of the formula under A and B, one can be liable to the charge for HICPIC, even though you yourself haven't received the child benefit, because it could be your spouse or civil partner, for example. Now, how does that all interact with the Taxes Management Act, which is the sort of procedural act in terms of at least personal taxes? If we take that up and go back to tab 1, the first provision there on page 7 is section 7. And that provides that every person who is chargeable to income tax or capital gains tax for any year of assessment and falls within subsection 1A1B, which we'll come on to, shall, subject to subsection 3, give notice to an officer of the board that he is so chargeable. So anyone who is going to be liable, who hasn't already given a notice, for example, has to obviously let the revenue know, and in due course we'll see that the revenue then have to send them a notice to complete a tax return. Now, if we then jump on to section 1A and 1B deal with the section 8 provision, but if we just jump on to subsection 3, which is over the page on page 8, you can see that this is as amended. A person shall not be required to give notice under subsection 1 if the person's total income consists of sources falling within subsections 4 to 7. I'll deal with that briefly. The person has no chargeable gains, and the person is not liable to a high income child benefit charge.
Would you accept that drafting suggests that HICPIC does not constitute income?
I would accept that when the draftsman drafted that, he was aware of the need to put that provision in, since otherwise there might not be a requirement to file, to give notice of liability. I don't accept necessarily that when the drafter of this provision or amending this provision put that in place, he also understood that it wasn't going to be income within the meaning of section 29. That's ultimately the heart of the purpose of argument.
Well, to be sure, but this is not section 29.
No.
It's section 7, subsection 3, that if one excludes the consequential impact or otherwise on section 29 for the moment, on the face of it, this appears to suggest, does it not, that HICPIC is not income?
Absent any other considerations, yes.
Thank you.
So what this does is, one is relieved of an obligation to file a self-assessment return if one hasn't got any liability to HICPIC, but also if one's income is otherwise essentially going to be dealt with via other means. And for example, subsections 4 and 5 deal with PAYE. So this is why many taxpayers don't in fact have to file a return, because all of their income is going to be dealt with by PAYE instead. Equally, subsection 6 deals with withholding at source, and 6A deals with dividends, and 7 is if it's a source of income where you wouldn't be liable under self-assessment in any event. So the issue for Mr. Wilkes was, until HICPIC was introduced, unless he received any other income which was chargeable, he could rely on the exemption for PAYE. But what happened then, once HICPIC was introduced and section 7 was amended, was he then had a very clear obligation to give notice of liability.
Not that it matters, but as I think you explain elsewhere, HICPIC can be recovered through PAYE.
It can.
But it remains the case, does it, that if you are liable for HICPIC, you still have to notify, because subsection 3 won't apply.
It would, yes, because you can't rely on, for example, 4 and 5, because that clearly C is obviously a standalone section.
Yeah.
So that's section 7. Then, very briefly, if we turn on to section 8. That's what obliges you to file a personal return. So if you're only under an obligation to file the return if you've received the notice. You'll see reference in the skeletons to a case called Patel about what status voluntary returns have. I don't propose to get into that now. If we then go to section 9, it's page 15 of the bundle, returns to include a self-assessment. And the self-assessment includes, under sub 1A, an assessment of the amounts in which, on the basis of the information contained in the return, and taking into account any relief or allowance, a claim for which is included in the return, a person making the return is chargeable to income tax and capital gains tax for the year of assessment. So it talks about amounts which are chargeable to income tax, as opposed to just income. Once you've filed your return, the revenue then have a right to inquire into that return. And that's set out in section 9A. That's on page 18. And the revenue are allowed to do that as of right. There's no precondition they have to satisfy. They just have to give notice. The only condition is the time limit, which sometimes you'll see referred to as an inquiry window. But typically that's going to be, as set out in sub 2A, period of 12 months from the day on which the return was delivered, assuming it was filed on or before the filing date. It's not in the bundle, but once the inspector has, or the officer has concluded that return, they give what's called a closure notice. And that's set out in section 28B section 28A for an individual. And that closure notice itself is then appealable to the first tier tribunal, for example, if the taxpayer disagrees with it. The alternative power, there are then a series of alternative powers which the revenue can rely on. The first is under section 28C, which is the determination provision, which is where the revenue have given notice to the taxpayer, but no return has been received. And essentially, what the revenue are allowed to do under 28C is determine the amount of tax. And as you can see under sub 3,
Where are we?
this is page 23 of the bundle.
Thank you.
Until the taxpayer files their own self-assessment, the determination stands as if it were a self-assessment. So notice has been given to the taxpayer, they haven't put in their return, the revenue determined matters, and that stands as a self-assessment. With the consequence that you can't appeal the determination, because one can't appeal a self-assessment either. So the only solution for a taxpayer in the face of the determination is to actually put in their return, which is obviously what Parliament wants you to do in any event. If we then move on to page 26, we can see 28H, which has received quite a bit of commentary, I think, in the upper tribunal and in the party skeleton arguments. And this is a relatively new provision introduced in 2016, termed a simple assessment. And it doesn't apply if you filed a return. That's one of the preconditions in sub 2. But it does use language which doesn't depend on there being income. Again, if you look in sub 3, it talks about an assessment of the amounts in which the person is chargeable to income tax and capital gains tax. And the only real condition in relation to the simple assessment is under sub 5, which it must be based on information relating to the person that is held by HMRC. And at least in terms of the policy papers which were published rather prior to the introduction of this section, the policy aim, at least as announced by the government, was that for certain individuals, rather than making them go through the rigmarole of having to file a return where they have relatively simple affairs, the revenue instead would just issue with a simple assessment because, for example, they know what your state pension is, or they already have the PAY information on file. So rather than giving you a notice, you having to file the return, revenue just themselves don't inquire into it, they can just issue a simple assessment which the taxpayer can query if they want, but otherwise it saves them a procedural burden. But as I say, that was introduced 4 years after the HICPIC charge. And then we come to section 29, and I've already taken you to sub 1. But what broadly this does is, if, for example, the revenue have, if there's no return, revenue can use this power, obviously, or equally, if the taxpayer has filed a return and the revenue have missed the inquiry window, they can use this power insofar as they discover there's further amounts of tax due. However, where the taxpayer has filed a return under section 8, this is picking up the words of subsection 2, various protections then arise for the taxpayer. So if one just looks in sub 2, you're entitled to the protection that if you filed on the basis of a practice generally prevailing, the revenue can't issue a discovery assessment. And equally, under sub 3, where the taxpayer has delivered a return under section 8, they're not going to be assessed unless one of 2 conditions mentioned below are fulfilled. We'll come on to those. The first is condition 1, which is in subsection 4, which is the loss of tax has to be brought about carelessly or deliberately by the taxpayer. The second condition is a slightly tortuous test, but it essentially requires that if the officer had all the information in the return and other prescribed information set out in subsection 6, then on the basis of that information, if the officer could not be reasonably aware of the situation, the officer would be entitled to make a discovery assessment. So this ultimately, this has taken a lot of time in the Court of Appeal to resolve what the meaning of subsections 5 and 6, starting with Langham McBell Teamer, and then continue on to a case called Sanderson, where my Lord Justice Newey was in the upper tribunal. But essentially, the end conclusion of all that is these provisions are dependent upon the quality of the disclosure given by the taxpayer. So if the taxpayer, for example, is unsure about a particular provision, but they put enough information out on the return, which flags the issue to the officer, I paraphrase, then if they've done enough in terms of their disclosure obligation in the return, that could shut out the revenue from making a discovery assessment. Unless, of course, the revenue could make could get a case under subsection 4, I say it was careless or deliberate. And all of these extra protections were introduced at the time the self-assessment system was introduced. So none of this appeared in the original section 29. And the whole idea was, under the new system of self-assessment, once you filed your return and you've given enough information in it, the taxpayer was entitled to finality vis-a-vis the revenue after a period of a year. That's the broad gist of it. Discovery assessments themselves are subject to time limits, and we can see those time limits set out in sections 34 to 36. 34 is found on page 40. And you can see there an ordinary period of 4 years from the end of the year of assessment. So the time limits therefore work slightly differently. For an inquiry window, that year runs from the date of in a normal situation, the date when the return is filed, which is obviously after the tax year. So, take for example, tax year 1, the return is only going to have to be filed by the 31st of January, for example, in the following year, tax year ending in April. The discovery assessment time limits run from the end of the tax year itself, not from the date the return is filed. So that would expire, for example, on the 5th of April. That time limit itself is then extended. By the way, just in passing, in sub 3, you can then see a provision which says this assessment does not include a self-assessment. So that's really giving effect to a point decided in a case called Higgs, which is in the bundle, but I don't need to take you through now. As a result of that case, a time limit for self-assessments was introduced in section 34A, which you can see at page 42. I don't want to spend any time on that. But then if we go to section 43, extended time limits then exist under sub 1. It's a period of 6 years if the loss of tax has been brought about carelessly. And then under 1A, a period of 20 years exists for several matters. One is loss of tax brought about deliberately by the person, but also B, you'll see there attributable to a failure by the person to comply with an obligation under section 7. That's the notification of liability. Now, I think it's also worth at this stage just jumping back to what the old section 29 used to say, and that is found behind tab 2 at page 61. So this is the pre-self-assessment regime. And you can see it in subsection 1, except as otherwise provided, all assessments to tax shall be made by an inspector. And essentially how this provision worked is you still had to file a return, it just wasn't a self-assessment. And what happened is the inspector then assessed you based on what your return contained. And if you disagreed with that, you could appeal or whatever. But that was the equivalent of the self-assessment under the old system. Under sub 3, we find the analogous provision for what is now section 29.1. So a discovery assessment. And you can see the wording, leaving aside the extra wording we saw on the current 29, which I can come to, is essentially the same. And what essentially happens, and this is a point which is made by the upper tribunal, is the self-assessment obligate, or the self-assessment provision under the rewritten TMA gets put into section 9, which I've already taken you to. And rather than profits, I should also say profits are defined in sub 8 over the page, but profits in relation to income tax means income. What happens when the self-assessment provision is brought in relation to section 9, the draftsman doesn't use the word profits or income. They use amounts chargeable to income tax. But sub 3, which then becomes sub 1, remains the same. And ultimately, a lot of the arguments...
Sorry, just remind me,
of
self-assessment is 94 or 98?
94. But there's
a
legislation.
two-stage change. In 94, you still use profits. And in 98, it's changed to income.
Correct. I think that's right, yes. Yeah. But nothing turns on that given the definition.
Because profits anyway meant income, but for some reason it's a two-stage change.
Yeah. Meanwhile, in 98, what happens in 98 is the TMA equivalent for corporation tax gets moved elsewhere. It's put into Schedule 18 to Finance Act 1998. And curiously, obviously, the drafter of those provisions, the equivalent of the discovery assessment, uses the word amount rather than income, for example. So, post 98, UK resident companies at least are taken out of the TMB and put into Schedule 18. Non-resident companies, i.e. those who aren't incorporated here and aren't centrally managed controlled here, but might have income from the UK, they're still actually subject to income tax. That's only relatively recently been changed. But a lot of the debate about the purpose of Section 29 is what import does one read into the fact that 29 stays the same, but Section 9 then alters. Is that a deliberate choice? Is that a conscious choice?
And just focusing our minds for a moment, what we are concerned with is what Section 29 meant either in 1994 or 1998.
Yes, I think that's right.
And
Because
there's, I dare say, no significant difference between 1994 and 1998.
indeed, and the question is really, in subsection A, is that really intended as a restriction on the power of the revenue to issue an assessment? Or is, when this provision is drafted at least, Parliament simply providing for all possible scenarios where income tax is going to be due? And does that really alter in light of changes made elsewhere, both in the TMA and the introduction of new changes, such as HICBIG? Does that mean that Parliament intends that those fall out of Section 29(1)(a)? So does income really have a meaning of that import in Section 29(1)? And that's really the purposive argument in a nutshell. Before we get to the arguments, I just want to take two further provisions. The first is Finance Act 2012, and the second is, very briefly, some of the pensions legislation which is in the bundle. So, Finance Act 2012, that's behind tab 9, and is found at page 228 of the bundle. So first of all, we have Section 8, which then introduces Schedule 1. And Schedule 1, Paragraph 1, is all the substantive law which you've already been taken to. So if we then turn to the page 233, we can see Paragraph 2. The words, a new subsection is introduced. So one takes out his total income and to the end of the previous subsection. And then one has this new provision which obviously specifies HICBIG.
And that's the provision that you were telling my lord we should worry about in the INCO context.
Yes, because what the draftsman does is he amends subsection 7, but he doesn't amend section 29.
Yeah.
And in light of all the anomalies which we say arise from that, on the assumption that you're not with us on the purposive interpretation, we say that's just a glaring error. There's no real... There has been an attempt at rationalisation of that, both by obviously those acting for Mr. Wilkes and by the upper tribunal, but we say that really can't be what Parliament intended. It's actually bizarre that in some situations you can use 29, but in others you can't, and then you have to go through various other systems. So we should say that that's just a glaring error, and the draftsman just didn't appreciate that. Whilst he appreciated he needed to amend section 7, he didn't appreciate that by parity of reasoning. This is my Lord Justice Arnold's point. Leaving aside purpose of interpretation, section 29 needed to be amended as well.
Yeah.
So that's Finance Act 2012. And then, if I may, can I just turn to tab 6 of the bundle, to the pensions legislation. I mean, this isn't a pensions appeal, but this just highlights some of the other issues. You can see pensions were listed in the amending legislation, the retrospective amending legislation is one of the other issues which arise. And if you turn to page 97, you can see that there's a charge. This is an unauthorised payments charge. Charged income tax, known as the unauthorised payments charge, arises where an unauthorised payment is made by a registered pension scheme. So that could be a payment to an employer if it's not an authorised employer payment, or it could be a payment to the member. It doesn't really matter. And then over the page, you can see Parliament has been very clear that this charge is not to be treated as income for any purpose of the Tax Act. So Parliament's actually gone out of its way to say this isn't income. Oh, the payment. Sorry, Mr. Lance quite probably just pointed out it's not the charge that's not treated as income, it's the payment that's specified. And what happens is that under further regulations, the revenue do create separate powers for them to assess this charge, but only for companies. So in relation to, that's the best way of dealing with this. I think if we could just go to page 120 within tab 6. You can see the registered pension schemes accounting and assessment regulations. And if I can just ask you to turn to page 125. You can see a table 2 with various cases set out. And it's worth just focusing on cases 1 to 4. And you can see cases 1 to 3. 1 has to be a company, 2 it has to be a company, 3 doesn't. We'll come on to that. And then 4, a charge to tax arises under section 239, which is a scheme sanction charge, which is a charge not on the person receiving the payment, but on the person who's running the relevant pension scheme. If we then move on to regulation 9, you can see that section 29(1)(a) is amended with the following modification, but only in relation to an assessment under case 1, 2 and 3, not generally.
So when we saw back in the version of section 29 that you took us to the words be put in generally, that's misleading.
Exactly. That only applies, you only get to see those words if you're in a 1, 2 or 3 scenario.
Yes.
What, just in passing, case 4 is found, if you look at regulation 4, it doesn't actually offer the revenue any discretion. It says the revenue must issue an assessment to the assessable person specified in column 2. And what is found to be the case in a case called Bella Figura, which is in the bundle, in Properties Bundle 2, tab 23. I don't intend to take you to it, do I? Page 513. Is that case 4 itself, those simple words in paragraph 4.1 and the specification of case 4 is an assessment power itself. That's the decision of the upper tribunal. Yeah. So in relation to pension charges, some new powers have been introduced by virtue of these regulations. But they wouldn't apply, for example, just to an individual receiving an unauthorised member payment, for example. The revenue would still face the same problem under section 29(1)(a). For example, if it's just a big lump sum payment. And we're told by sub 8 that that's not going to be income, even if one thought it might be income on normal principles. Sub 8 tells you it's not income at all. So the question, a very similar question arises in relation to pensions as arises in relation to So that really just leaves me then to go through what the revenues case is on those three issues. And the first one is obviously the purpose of interpretation. The principles which are set out by the upper tribunal, and I think let's just turn to the decision, aren't really in dispute, I don't think. So those are set out in paragraphs 43 to 49. And so if you go to the core bundle, that's at tab 6, and we want to be on page 88 of that bundle. And if I may, can I just invite you to read 43 through to 48?
You don't challenge this.
No, I mean it's
standard form.
It is.
Standard, yep.
Purpose of interpretation, avoid absurdity if you can. The real issue between the parties is there absurdity or anomaly? There are certainly anomalies, but whether they're so absurd that's a strong enough steer that one has to try and avoid it, or whether you can live with it, or indeed, no matter how strong the absurdity is, are you really stretching matters by treating the word as income to read amounts chargeable to income tax, for example? Is that really stretching purpose of interpretation too far, regardless of how strong the absurdity is?
And just to be clear, the absurdity would have had to exist by 1998.
The absurdity, I think it would, the potential for the absurdity would have to exist by 1998, i.e. there's an amount, I'm not saying HICBIC has to exist, obviously,
No.
But there's that discrepancy between the wording of section 9 and the wording of section 29. And is it Parliament's intention that there's the potential for amounts which have to be self-assessed, where the taxpayer hasn't self-assessed, which aren't income, where the revenue just don't have the power to assess that?
And as you say, what one may be concerned with is potential rather than actuality. But if one were to look in 1998, would there have been situations where Section 29 would not have applied because little a referred to income rather than amount?
I can't give you an answer immediately right on that point as at 1998. There are certainly some issues which are raised within the upper tribunal decision, but there's, by virtue of just the difference in wording, and we're focusing on the import of, is there any import in Section 29 remaining as it is? Did that really mean anything at all?
But if the position is, back in 1998, income worked perfectly well, the mere fact that it might look absurd later on when HICBIC came in or the pension charges came in would seem to be a consequence of the later legislation rather than the wording of Section 29.
That's certainly true in relation to both HICBIC, that's 2012, and obviously the pension charges, because those come in via Finance Act 2004. So yes, and I'm sure that's what Mr. Black's going to be saying. You've just made a rod for your own back by being too clever by creating these non-income income tax charges.
Yeah.
But we would say that the purpose of Section 29 is to capture anything which should be in a self-assessment, regardless of whether that divergence exists at that point in time or not.
I mean, I quite follow how you put it. At the same time, the point would have more obvious force if in 1998 or 1994 there had been some item that would have represented an amount chargeable to tax which was not income.
Yep, I fully accept that. So the revenues case and outline is the purpose of Section 29 is to empower the revenue to raise an assessment to make good a loss of tax, generally. The upper tribunal was wrong to read in any significance to the difference in wording used in section 9 versus Section 29. There's no rationale as to why Parliament would have intended there to be such a discrepancy. Obviously, there's arguments about how useful Section 28H is, for example, but obviously that was only introduced much later on. There's no suggestion, other than the word itself, that it was Section 29(1)(a) was intended to be restricted to items of pure income. i.e., it was not intended to capture everything which would have been in the self-assessment return. And we would say that any other interpretation does lead to absurdity. Just in terms of that absurdity argument, the workaround that would have to happen is in relation to take a situation where the taxpayer has filed a return. There's no dispute that the revenue could go under Section 29B in that scenario because an assessment has become insufficient. An assessment in Section 29(1)(b) would include a self-assessment. So very clear that the revenue could use their discovery power there. That would include, obviously, the extended time limits in the cases of carelessness and deliberate conduct, etc. The situation, assuming Mr. Wilkes is right about Section 29(1)(a), is that the revenue couldn't use that power. They would have to, off their own volition, issue a Section 8 notice to the taxpayer. And one of two things would then happen. Either the taxpayer files the return and the revenue is still not happy, in which case they could then go down to Section 29(1)(b). Or if the taxpayer doesn't file a return, they could use the determination power in Section 28C. That route is itself complicated by the fact that until relatively recently, at least the revenue, possibly Parliament, who knows, didn't appreciate that there was no time limit for a self-assessment. So there's no time limit, therefore, on the ability to give a notice to complete self-assessment either. So in light of the law as we know it now, there would, at least until the law changed, there would be no limit on the revenue issuing that notice, say nearly 20 years out, and requiring the taxpayer to issue, to complete their self-assessment, failing which you could issue a determination. But that certainly wasn't known at the time. It was obviously a point which has now been resolved, but that was at least unclear. So, and this is the point we raised in the Skeletonis, the point that was raised in the upper tribunal. The revenue has a stronger power under Section 29(1)(b) in relation to a compliant taxpayer who has filed a return, compared to a taxpayer who, maybe deliberately, maybe not, hasn't notified their liability to the revenue under Section 7. Now, the fact that there may have been a workaround by issuing a Section 8 notice because the revenue knew that there was child benefit being paid, etc. That would be quite an odd way for Parliament to have decided to proceed in circumstances where there's no real policy rationale as to why Parliament would want the revenue to go to that trouble rather than simply issuing a Section 29 or something. There's no indication anywhere that would be expected. I mean, there's obviously nothing in permissible legislative aids which suggests that was the plan when self-assessment was changed. It is anomalous. I don't think there's any dispute it's anomalous, but we would say it's so anomalous as to be absurd. Why would Parliament want the revenue to go to that trouble? And potentially, at least, be shut out much earlier in tackling a taxpayer who didn't file a return compared to one who did. So not only the administrative rigmarole of having to go through Section 8, then deciding whether to go down a determination or a 29(1)(b, and also the time limit point. So there's two issues there, as opposed to just using Section 29(1)(a), which doesn't add any greater power to the revenue compared to Section 29(1)(b). It's simply just another scenario which Parliament has listed within Section 29. So that's the anomaly. There's been quite a lot of debate about when HICPIC was introduced. Revenue obviously had administered child benefit, but that's not conceptually relevant, we would say, to what happened in 1998. Nor would we say the fact that the revenue could, if it had thought of doing it, because it wasn't its real intended purpose, Section 28H, it could have recovered child benefit using that mechanism. But obviously that wasn't in existence, either in 1998 or indeed when HICPIC was introduced in 2012. So, with all due respect to the upper tribunal, we think the Section 28H issue is a bit of a red herring.
I mean, I do follow that. But in a sense, that's because we're back to 1998. And if we're back to 1998, the anomaly created by the 2012 Act might be thought to be a red herring as well.
I can see that point, my lord. The reason why it's relevant is that the focus, at least of the upper tribunal's reasoning, was that the change in wording between Section 9 and Section 29 was somehow a deliberate break, whereby Section 29 sort of ceased to become part of the self-assessment system. Maybe I'm reading too much words into the upper tribunal's reasoning.
Can I put my lord's question in different words?
Yes.
So, your proposition, which is a very simple and straightforward one, is that the upper tribunal fell into error by making the elementary mistake of trying to construe earlier legislation by reference to later legislation. You say, well, you can't do that, because unless the later legislation amends the earlier legislation, then the meaning of the earlier legislation has to be judged as at the date it was enacted or last amended. And in the present case, that means you construe Section 29(1)(a) as at 94 or 98, doesn't matter. That's a perfectly straightforward argument. But what my lord is putting to you is, well, what's sauce for the goose is sauce for the gander. If Mr. Wilkes can't rely upon the later legislation as casting meaning on Section 29(1)(a) as at 98, neither can you.
I would accept that. But what we're focusing on is the difference in wording in Section 9, which was there in 1998, and did obviously anticipate that there was a deliberate choice to stop using the word income in Section 9. And the question is, what is the import of that? Is it a deliberate break between Section 9 and Section 29? To be fair to the upper tribunal in relation to Section 28H, I don't think it was attempting to use it to construe Section 29. I think the import of Section 28H in the argument below was to somehow lessen the anomaly. as opposed to directly being relevant to the interpretation of earlier legislation. And we would say if it is an anomaly, it still has to be that workaround can't lessen that anomaly simply because it's introduced at a later date.
Yeah.
If I may, if we can just turn to the upper tribunal's reasoning. If we turn to page 95 of the core bundle, and it's paragraph 68. So there's a discussion there of HICPIC and self-assessment, and there's no doubt that Parliament intended HICPIC to come within self-assessment. But then, if you go on to 71, I just invite you to read that. And then once you've finished that, if I could ask you to read paragraph 74. Now, we say the upper tribunal just reads too much into that. Section 29 is plainly part of the self-assessment system. I mean, much of the rewritten provision is concerned with protections for the taxpayer, assuming they have complied with the self-assessment system. And we would say that to suggest that this close connection has somehow been lost simply because Section 29(1)(a) has used its old wording, hasn't been amended or updated, we think just reads too much into it, and it's not strong enough to suggest that the purpose of Section 29(1)(a) has changed. Admittedly, Section 29 predates, in terms of archaeology, the introduction of self-assessment. But on any view, it is radically rewritten in light of the introduction of that system. Yes, older wording is retained.
What do you say about paragraph 76?
What we say about 76 is that that three-part structure was intended to be comprehensive. It wasn't intended to leave something out or somehow operate as a restriction on the revenue's power. It was simply trying to anticipate every possible scenario where there would be an insufficiency of tax.
Can I just try to understand the significance of the point? I mean, what we're ultimately concerned with, obviously, is what Section 29 means. It obviously has a role in relation to self-assessment, but it has a role in relation to other things as well. I'm not quite sure why it matters so much whether there's a break with the introduction of self-assessment.
I think when the upper tribunal is saying there's a break or it doesn't form part of the system, I mean, on the face of it, it looks very stark in terms of the outcome, where on the face of it, Section 29 is a huge part of, or at least a backstop, as my own friend accepts in his curtain, a backstop to self-assessment in the inquiry system. It may well be that the point which is being made by the upper tribunal here is you can't assume that Section 29 is going to be comprehensive in relation to everything that's within a Section 9 return. If that's what is meant by the link with self-assessment, maybe that's a more accurate way of putting it. But that's obviously the very issue which we're faced with.
Yes.
is the implication of Parliament retaining the old wording of the pre-self-assessment section 29.3 by transferring it up to section 29.1a. Is that intended to be anything other than a shorthand for anything which is going to be liable to income tax or chargeable gains? Or does one read the word income as being some sort of restriction? So anything which is chargeable to income tax but isn't income can't be assessed under section 29.1a. Is that Parliament's intention?
Yes, I mean, you perhaps put a spin on it by suggesting that Parliament intended a limitation. In another sense, it was just saying what could be within section 29.1a income. So then I suppose the question is, do you attach any significance to the fact that section 9 talks about amounts and section 29 talks about income? And I suppose that could be spun either way, I don't know.
I think that's why we're here.
Yes.
And not assisted by, for example, further confusion when the draftsman comes in and deals with section 7 when HICPIC comes in. Parliament clearly doesn't think it's necessary to change section 29, unless you think it's intending this whole rigmarole, slightly convoluted system for recovering HICPIC where no return is fine.
And I follow that, but then we do come back to the point that we're construing section 29 as at 1998, and whatever Parliament may have thought in 2012 doesn't seem to give you much of a guide to what it meant in 1998.
No, I accept that. So ultimately, the issues aren't in dispute. I think the issue really does turn on that relationship between section 29 and section 29.1a, and what the retention of the old terminology, pre-SA terminology, means in section 29.
Yes, so you say, well, section 29 was intended whatever else it did to act as a sweep up to self-assessment. Self-assessment was intended to cover amounts subject to tax. Why wouldn't section 29 have been intended to cover the same?
Indeed.
But in another sense, if in 1998 or 1994 Parliament thought that income should be extended to amounts, well, A, didn't say so, but B, there's no evident absurdity as of 1998.
Nothing I can point to.
And the Appellate Tribunal buttresses its interpretation in a number of ways. We've
Particularly 79, yes.
first of all, the point on 78, and then the other provisions from 79 onwards.
The references to the other provisions, the significance, if there is one, is, well, Parliament can talk about amounts when it feels means to talk about amounts, and here it didn't.
Yes. Is this a carefully drafted differential approach, for example, between section 9 and section 29.1a, or is this a case where the purpose of section 29 just hasn't been construed against the other body of the provisions in relation to which it's supposed to interact? The wording doesn't quite get there on purpose, and whether you get there as a matter of purpose of interpretation or as a matter of encode. I mean, the encode, I'm not running an encode point as at 1998. My encode argument is going to be in relation to FA 2012.
Yes.
And then there's what's said at 86 onwards as well. And are you going to say anything more about the other provisions?
I don't want to.
have covered all of this in your skeleton.
Indeed. I mean, I don't think there's nothing where I can say, aha. Look at paragraph X. Look at the fatal flaw in the reasoning there. All these points are fair points against me. The question is, where does the balance lie?
Same vein, I suppose, when you come on to section 30 and section 32 of the Income Tax Act and so on, this is all post 1998.
It is, and there's 2 points. First of all, there's a discussion at 84 and 85, just dealing with the peel-off for corporation tax and how the draftsman uses different wording there.
Yes.
Again, the relevant provision, paragraph 41, I don't think it's in the bundle. It is a rewrite of section 29(1)(a), but it's interesting the draftsman there just uses amounts. Now,
why we don't know.
Why we don't know, but one can see an argument that the draftsman just views that as interchangeable. So there's no special meaning of the word income.
Or it's deliberate.
Or it's deliberate. But in relation to section 30, and there's this whole debate about, to take the nice steps we see set out in section 23, and you have all these charges in section 30. That's all very nice and neat in Income Tax Act 2007. It is said that all derives from section 835 of ICTA. We can go to that, but in my respectful submission, that's quite a stretch. Maybe we can just go to that now.
Well, they do say, although we do not place much weight on that,
indeed.
There's an interesting gradation of the weight attached to all these subsidiary points.
There is.
In particular in 79, and then worth noting in 84, and then worth noting, although we do not place material weight on it in 86. Anyway, carry on.
Indeed. I mean, that very strict separation and nice listing of all the various charges just didn't exist in 1998.
No. But it's not material on there. It's not material to the other.
It's not material on them. I can't say that's an error in their reasoning because they haven't placed any material weight. But that's the purpose of argument.
Well, do you want to say about what the upper tribunals, anything more about whether the anomalies rise to the level of absurdity, 93, what it said, or have you covered all that?
Well, I do say that if you look at the anomalies at 93 to 95, at 95 it's said it's not irrelevant that HMRC administer child benefits. That can't be relevant to the potential anomaly in 1998. So the fact that there is one particular form of non-income income tax liability, which the revenue administer, that can't sort of justify an anomaly between section 29 and section 9 as at 1998. So that can't be relevant. So a lot of this is very HIPIC focused, whereas this first point, this purposive argument, if the revenue are right about it, it's not only going to solve the problem of HIPIC, but it will also solve the problem of the unauthorised payment charge. Quite accept some of the later arguments, so the Wiseman argument and the Inco-Europe arguments are very HIPIC focused, but at this stage, it is slightly confusing why this comes into a purposive interpretation of section 29.
Well, you did say it's a potential anomaly, didn't you? Or not?
There is going to be a potential anomaly if you have something within section 9 which isn't caught by section 29(1)(a).
Yeah.
But you can't
Only
assume
potential, so it crystallises at a later date.
it does crystallise. Well, it crystallises first with FA 2004.
Yeah.
Um,
And in determining whether it has crystallised, isn't it relevant that the revenue administer the benefit?
But if one is taking into account, that would have to involve the following argument, that when one is thinking about potential anomalies in 1998, you can wish those all away by assuming that whatever anomalies exist or will come to pass will all be administered by the revenue. And the revenue are going to have some special knowledge in relation to that. I don't accept that.
Can I just go off on a tangent for a moment? You pointed out that the HICPIC bites either where your partner has received child benefit or potentially where you have received child benefit. How does all this work where you have received child benefit? Is the child benefit then your income?
If you look at the structure of Section 23 and the way it's all laid out, that would strongly suggest that Parliament doesn't regard this as a charge on income. You could debate whether child benefit is income in a sort of prima facie way, but I think that by the time you get to...
It's a clawback of a benefit.
It is a clawback of a benefit, and it doesn't operate like a normal tax if you think about it, because it's a charge. You're not applying a standard rate of income tax on it. You're just imposing this charge to income tax, which equals entirely the...
I mean, it's making it by a rather indirect route, means tested as opposed to universal.
It's going to be no part of our case that if you happen to receive it rather than your spouse, the revenue can get you under Section 29(1)A.
No. So if the upper tribunal is right, then it doesn't matter whether you receive the child benefit or your partner receives the child benefit.
It can't tell.
Assess either way.
No, I think that's fair. Oh, is it? Indeed. So I can't rely on, well, if you happen to receive it yourself rather than the other person. That's no part of my case.
No.
So if I may, could I turn on to the Wiseman point?
Yes.
So the Wiseman argument was first articulated by the FTT in a case called Wiseman, and that's, I'm not going to take you to that, but that's in Authorities Bundle 2, tab 24, and the case starts at page 538 of the bundle. But the reasoning on this point, because many other issues are dealt with in that case, is at paragraph 238 and following, which is on page 579 of the bundle. The revenues argument before you is this. Due to the liability to HICPIC, Mr. Wilkes was not exempted by Section 7 from giving notice of liability to tax. And as we belatedly know, I think from footnote 5 of Mr. Wilkes' skeleton argument, it was also the case that he had some modest amount of dividend income as well, which again would have meant that he would have had to comply with self-assessment, so that would have been taxed. So his income, following a notice from HMRC, therefore ought to have been assessed. And the fact that there was a PAYE credit for his employment income is irrelevant for these purposes, because that doesn't affect the operation of Section 8, 9 and 29. And we know that from a recent decision of this court in a case called Newey. And so, therefore, there was income which ought to have been assessed, i.e. his employment income, and indeed the dividend income, which has not been assessed. And so the question we would say is that not so much whether Section 29(1)A is satisfied. There clearly is income which ought to have been assessed. The real question is whether this is sufficient, a sufficient basis in order for the revenue to assess tax for the HICPIC. So again, if we just turn to Section 29(1)A, so the Authorities Bundle 1, tab 1, page 29. There is income which ought to have been assessed because his employment income ought to have been self-assessed. The question is that going to be enough to justify or authorise the officer to make the assessment by reference?
Isn't the whole argument circular? Because we're only considering this argument if you failed on ground 1.
Yes.
Because if you were right on ground one, you wouldn't need this because we would simply read income as meaning amount. And therefore, we have to proceed on the basis that when section 29(1)(a) for this purpose says income, it means income. And so your argument is, well, due to something that is not income, you've got to take into account that something which is not income when assessing the income.
I don't accept it's circular, so I don't accept the reasoning of the upper tribunal at 116 to 117, because that isn't really the argument the revenue are running in relation to Wiseman. I accept this is only relevant if I lose ground one. So income has to be something other than the hit big.
Yeah.
There is clearly income here, which is his employment income. He is not exempted from self-assessment by section 7 because of the hit big. Therefore, he should have filed a self-assessment for that income, i.e. that income ought to have been assessed. Respectfully, I don't view that as open to real contention. The question really is the link between condition 1A being satisfied and the making of the assessment.
Yes.
And obviously, in making the assessment, the officer can only make the assessment to hit pick if he's satisfied that Mr. Wilkes' income is over a certain amount. Quite except Mr. Wilkes' income was over £60,000, I think, for every year. There's no fine-tuning of that by reference to the percentage we've seen. It's simply just the flat reversal of the child benefit. The question really is what is the link between the satisfaction of 1A and the assessment? And if we turn to the upper tribunal's decision, the reason I don't accept 116 is right is really two. We're not relying on the income which ought to have been assessed is the employment income which ought to have been self-assessed. And I don't think 116 quite captures that point. And that's why you end up with the circularity or the fact that it doesn't really add anything to ground one. I don't accept that. You then get a further argument, really at 118 and following, which is I think really grappling with the real point. So at 118, the upper tribunal finds that the focus is therefore on the particular loss of tax in question, i.e. there has to be a relationship between the assessment and the discovery of under 1A. And ultimately the reasoning of the upper tribunal is the link between HICPIC and the employment income, or the any income which ought to be self-assessed, isn't strong enough. And that is really the crux of the argument, in my respectful submission, on the Wiseman point.
The loss of tax has nothing to do with income not being assessed.
That is the upper tribunal's reasoning, yes, exactly. And the question is, when the officer does assess HICPIC, is he also assessing, in some way, the other employment income, where on the face of it, the assessment simply just imposes a charge to tax?
So what do you say about 121 in the draft?
Well, I quite accept the point that the once you're over £60,000, as in fact is the point made at 122,
Yeah.
it's not a very sensitive, tailored charge. It's simply a reversal of the child benefit. But it clearly, as a prerequisite, requires income over £50,000 in order to be in point.
Well, yes. It's 121. What do you think is? What do you say is wrong in the reasoning in 121?
Well, we would say that the existence of the link does make a difference, because if
Okay. Well,
Okay.
Yes, that's just an initial assertion. It's the rest of the paragraph.
Well,
Sorry.
okay, well, let's go on. The existence of adjusted net income in excess of £50,000 is a condition for a HICPIC to apply. I agree. We consider that it's clear from section 681B, which provides that the charge arises if that level of income is exceeded and certain, in our view, additional conditions are met. Mr. Wilkes had not paid insufficient tax on his income. Rather, he had paid insufficient income tax in the form of HICPIC. But we would, well, okay, but that's true in terms of that line of reasoning. But the real reasoning is why doesn't that link matter in circumstances where we'll take a different scenario. Let's assume that Mr. Wilkes' income was £49,000 in the year, and that had all been subject to PAYE. That's his declared income. But let's assume that he had actually also had an additional £12,000 worth of income, which hadn't been subject to PAYE. Let's say it was dividend income, for example. He clearly would have been liable to complete self-assessment. And clearly, Section 29(1)A would be satisfied, at least in relation to the 12,000. It must follow on the upper tribunal's reasoning in that case that even though the revenue had no reason to believe that child benefit charge would apply, etc., before discovering this income, they would be prevented from having assessed the extra 12,000 from also imposing the high income charge, the HICPIC. Now, why isn't that link good enough? We know from cases, a decision of this court called Clark, that when one's considering the scope of the discovery assessment, the relationship between the discovery and ultimately what is the scope of the assessment has obviously got to be led by the context of the background of the matter. So you can't just say I've discovered some rental income which you haven't declared, and then 5 years later say, oh, I'm going to invite the tribunal to amend that assessment because I've also discovered some dividend income which has only cropped up, for example. That's not this case. We would say here the charge to HICPIC is entirely dependent upon the amount of self-assessed income. And if it hasn't reached a certain amount, the charge isn't due. Put another way, the reason why the income hasn't been self-assessed is because Mr. Wilkes, and there's been no penalty applied, there's been no criticism of this, Mr. Wilkes didn't complete a notification of liability to self-assessment. The revenue didn't appreciate that that the conditions of Section 7 hadn't been complied with. The charge arising from HICPIC is entirely tied up with the fact that there is income which ought to have been self-assessed because of the failure of Section 7. Well, so I don't accept there's a circularity in relation to the word income, but it does follow through from Section 7.
It's in 121, the third sentence.
Yes.
It's a condition. The existence of adjusted net income in excess of 50 is a condition for HICPIC to apply, rather than the charge to the HICPIC being a charge on that income. That, I think, is the key part of that paragraph.
And I accept that, but I don't, in my respectful submission, I can't say that's incorrect. It's not. But I say that's not sufficient.
You say that's not a total answer to the Wiseman point.
No, it isn't, because Section 29(1)A is satisfied. There's a charge which arises as a result of that. The link is good enough, we would say, for Section 29. There's nothing in the jurisprudence of Section 29 which would say that that's somehow, it's not completely unrelated.
Just supposing, can we just look at Section 29(1) for a moment?
Yeah.
So that says, if HMRC discover that any income which ought to have been assessed to income tax hasn't been, so you say that's satisfied because there ought to have been a self-assessment in relation to the PAYE income as a result of the existence of the HICPIC.
Indeed. So the presence of HICPIC is the entire reason why that income hasn't been
Assessed.
ought to have been assessed.
And then it says the officer may make an assessment in the amount which ought, in his opinion, to be charged to make good to the Crown the loss of tax. Now, on one view, which I think was the tribunal's view, the relevant loss of tax has to be in relation to the income which hasn't been assessed. And you obviously don't accept that. Where, in terms of the argument that you've just been exploring, the question of the significance of the 50,000 or whatever, why is that really significant on your case? Or
the reason why the income ought to have been assessed is because of the receipt of child benefit. That is
Yes.
That's the only reason, leaving aside the dividend point, which has blatantly come to light. That's the reason why there's an obligation under Section 7. So that's the presence of the HICPIC and the liability to tax, which obviously flows from it, is the entire reason why the employment income ought to have been self-assessed. And we say that is a good enough link for the purposes of Section 29.
But if the argument against you is, well, the officer can only assess to make good the loss of tax in relation to income which ought to have been assessed, then the fact that the HICPIC might arise from a particular income doesn't seem to matter.
That would ignore the reason why the income ought to have been assessed, which is because of the receipt of because of the liability to HICPIC. So I don't accept it's a circular argument in relation to income, but it does depend upon the import of the words ought to have been assessed in relation to Section 7.
Yes.
And coupled with the fact that, and I don't demur from this, the charge is income dependent. So those are two factors.
I mean, I can quite follow how you can say, look, condition one is, well, the condition is that there's income that hasn't been assessed when it should have been. That's satisfied because there was employment income which ought to have been the subject of a self-assessment as a result of the existence of HICPIC. Therefore, the condition is satisfied. Therefore, the officer can make an assessment to make good the loss of tax, and we know that actually tax was lost in relation to the HICPIC. And I understand that argument. I'm not quite sure why the argument is strengthened by saying, well, the obligation to notify was linked to the existence of a particular income, or why the charge to HICPIC is linked to a particular income. I mean, if you're right, on the face of it, you've satisfied the condition that there's income which ought to have been assessed, and there's no need for the officer to be tied to that income when he's making his assessment in relation to the loss of tax.
Well, we do say there's no link. That's what we say in our skeleton. There's no need for a link. But if a link is needed, we say the link is good enough.
Yeah.
So with that, if I may, could I turn to Inco Europe?
Yes.
So I think the starting point is obviously the decision of the House of Lords in Inco Europe itself, and you can find that in behind tab 12, page 271. So this was a case which concerned an amendment made to Section 18 of what was then called the Supreme Court Act 1981, and in particular an amendment in Section 18(1)(g). And the amendment was made by the Arbitration Act 1996, which had replaced an earlier Arbitration Act. And you can see the, if we take up the judgment at 273, you can see between D and E the original, the wording which was amended, which is no appeal shall lie to the Court of Appeal, G, except as provided by Part 1 of the Arbitration Act 1996, from any decision of the High Court under under that part. And then if you read between E and F, you can see that the problem that creates. Essentially, it removed all right of appeal from the High Court in relation to an arbitration. Now, if we then move over the page 274, you can see Lord Nichols agreeing with the Court of Appeal in saying that we can't possibly have intended to, by sidewind, it was only intended to deal with consequential matters, removed such an important right. And you can see the reference in, between, really the paragraph at D, between Homan having nodded, which crops up in the upper tribunal judgment. What paragraph 37.2 was seeking to do, but on a literal reading of the language, failed to achieve, is also abundantly plain. And then you can see the original wording and the reason what had gone wrong between F and G lower down. And the problem was, under the original wording of Section 18, it was very specific as to what could be allowed under the Arbitration Act of 1979, where there was specific restrictions which existed for rights of appeal in relation to Section 1 or Section 2. And as Lord Nichols explains, really from paragraph H downwards, thus, and this is the first feature to note regarding Section 18(1)(g) in its original form, the phrase except as provided by the Arbitration Act 1979 did not mean except as enabled by that Act, because it didn't contain any provisions enabling appeals. But rather, in this context, the word provided meant envisaged or permitted. In more legalistic language, the phrase meant except in accordance with the provisions of the Arbitration Act 1979, those provisions being restrictions on appeal. So it was essentially just, the original wording was seeking to preserve the restrictions which existed there, but otherwise wasn't intended to restrict any right of appeal. And so what goes wrong is, obviously under the amended wording, it simply provides except as provided by Part 1 of the Arbitration Act, where that Act doesn't contain any provisions allowing an appeal. So then we come to the key part of the reasoning, and this starts at page 277. So no doubt the draftsman slipped up, and you can see what the reading in, which is alighted upon, is, and that's set out between B and C on the page. And then at the beginning of the main paragraph at E, you can see really the summary of the principle of Vinco Europe, which has obviously come up many times since. And I just invite you to read between E and G. Then very briefly, the next case I was proposing to take you to is the decision of this court in Pollen Estate. And this case concerns SDLT and involved two cases, but ultimately the anomaly which arose was that if a charitable trust acquired a property on its own, it was very clear that it would be exempted from having to pay SDLT. The difficulty was that on the wording of the relevant act, if the trust acquired property in conjunction with others who weren't, for example, charitable, on the literal wording of the legislation, there was no exemption at all. And ultimately, what Lord Justice Lewison finds is that is so anomalous, and there's no policy rationale as to why that would be the case, that one can read in the words to the extent that an interest in a property is acquired by the trustees. And obviously prays in the Inco Europe line of argument there. Much of this decision isn't really concerned with Inco Europe, it's actually concerned with, again, purpose of interpretation. Once that fails, you then come to the Inco Europe argument. So if I may, just turn to page 328 of the bundle and paragraph 49. And just invite you to read that paragraph. That judgment's important because many of the other cases involved slip-ups where a right of appeal was removed by a side wind, whereas actually what's obviously going on in this case is the court is use a term sometimes used in this context, rectifying the legislation to give effect to what the court believes is abundantly sure what the purpose of the legislation is, namely to give exemption to charities. And in the absence of any rationale as to why Parliament wouldn't want that exemption to apply where a charity is acting in conjunction with others, it was happy to read those words in. The other case which I'd briefly like to take you to is one tab back, which is at paragraph 14. And this is another decision of this court, Director of Serious Fraud Office and B. And if we turn to page 311 of the bundle. This was also a case involving the removal of a right of appeal. And that removal occurred in the context where, under the Court Martial's Act, the relevant statute was tidied up, so it was thought, to update reference to the Court Martial, the relevant martial court, but it also removed reference to the Court of Criminal Appeal because that court hadn't been in existence for 40 years. What the draftsman hadn't appreciated was that was the retention of that reference to the Court of Criminal Appeal was deliberate under the provisions which created the current Court of Appeal and its two divisions. And so that there was a reading back in terms of the old legislation as to what Court of Appeal meant and what Court of Criminal meant, i.e. it meant references to the civil and criminal divisions. And what went wrong was by removing reference to the Court of Criminal Appeal and just leaving the words in Court of Appeal, when one read that in the context of the original act, one had actually just completely struck through any right of appeal from the Court of Appeal criminal division, which obviously, there was no rationale for that and clearly wasn't the intention of the drafter. So, if one turns to paragraph 24, the passage, which you can see highlighted, runs all the way down to paragraph 31. The key part which the revenue rely on in relation to a point made by the upper tribunal is paragraph 28. And that is relied on because when one comes to the upper tribunal's reasoning in relation to INCO, at paragraph 142, that's on page 110 of the bundle. The point, one of the reasons why the upper tribunal doesn't accept that INCO Europe can apply is it's the wrong sort of error. So if you see from the 6 lines down, if, as we have held, that assumption was wrong on a purposive construction of the legislation, then it is very difficult to see how any error made by the draftsperson of Schedule 1, FA 2012, was the sort of slip that Lord Nichols had in mind. This was not simply a case of Homer in the shape of the draftsperson having nodded. Homer would have been under a material misapprehension. The facts are very different to, and then we see the, again, rationalisation by reference to, most of those cases are to do with removal of something by a slip, and then pollen is just found to be a case on its own, but again, not thought comparable to the present case. So we rely on the SFO case to show that if a draftsman has actually misunderstood how legislation, previous legislation operates, which it's then seeking to amend, that is no bar to INCO Europe applying if one can be abundantly sure of the other criteria which are set out. And indeed, if one actually drills down into the cases, in particular INCO Europe, quite often that involves actually a material misapprehension of the meaning of words. In our case, assuming we are wrong on the purpose of interpretation, the draftsman of Schedule 1 to FA 2012 was under a material misapprehension as to what the word income meant in section 29(1)(a), except that, if we're at this point. But in my respectful submission, that is really no different to every other form of drafting error which we have seen here. Yes, there are other features which are different, which I'll come on to that. But to say it's the wrong kind of error really has no, it's not really supported by the case law at all. Admittedly, the upper tribunal did not have the SFO decision before it. But in my respectful submission, that principle is relatively obvious from a reading of the other decisions mentioned.
So I can understand why you say that there's nothing in the case law to suppose that there's any particular type of drafting error that can't be corrected if the requisite criteria are satisfied. I get that. But even so, isn't it relevant to consider the nature of the error that you must be contending for in the present case to see if the conditions are satisfied? Because, as you've rightly said, we have to proceed at this stage of the argument by assuming that you've lost on grounds 1 and 2. And so therefore the nature of the error is that, on the assumption, and I think you have to assume this for the purpose of your argument, that when bringing HIPIC in, Parliament must have wanted to ensure that it could be subject to a discovery assessment if need be, and failed to appreciate that that required an amendment to section 29(1)(a). But how could we be satisfied, given that in fact no amendment was made, that it must have been Parliament's intention that it should be subject to a discovery assessment if need be?
I'd entirely accept that formulation. So I don't think there's a fourth test to INCO Europe that it has to be the right kind of error. My respectful submission, you're quite right to say the type of error is relevant to the 3 conditions, but it is not an additional condition in itself.
So so far you're quarrelling with the preliminary argument or INCO. And you're going to address the sweep up provision reasoning on 1 to 3.
Indeed. So you have to be abundantly sure of the purpose of the statute or the provision in question. By inadvertence, the draftsman failed to give effect to that purpose. And then you also have to be satisfied, abundantly sure of the substance of the provision that Parliament has made. So I will now engage with each of those. So the upper tribunal accepted, and it's not disputed, that by paragraph 2, the draftsman clearly intended for HICPIC to be brought within the self-assessment regime. We also say it must follow from that as well that it intended that Section 29 would apply. Stepping back, pausing for a moment, Section 29 does apply to HICPIC, but it only applies if a return has been submitted. So Section 29(1)(b), it's not in dispute that does apply to HICPIC. So what the draftsman was under a material error of is not appreciating that Section 29(1)(a) wouldn't apply.
Well, the upper tribunal's objection to that argument seems to be that there wasn't evidence. 145. We've been shown nothing to demonstrate that Parliament's intention must have been, as you assert.
I have to rely entirely on paragraph 2 and the amendment made to Section 7. I accept that.
But don't they dismiss that by saying the existence of the anomalies by itself is not sufficient?
Well, I mean, that is the rub, isn't it? So is that right or not? The anomaly would be that Parliament it amended Section 7 to bring HICPIC within Section 7 so as to require one to notify liability to tax. So Parliament intends you to file a return. If you file a return, Parliament must have known the consequence that if you fail to declare HICPIC, for example, on that return, that the revenue would have a power under Section 29(1)(b). The draftsman is also aware of the distinction of income in Section 7 itself, but fails to pick up the fact that he or she would also have to make a similar amendment to Section 29(1)(a).
Would you accept that one way of looking at this is in terms of rationality? Because your argument is that a rational legislator would have included this within Section 29(1)(a). But can you say that if the legislature had decided not to include it within Section 29(1)(a), that would be irrational?
We would submit that in the absence of anything else, it would be irrational. I think you have to meet a similar type threshold to be abundantly sure. In a similar way that Lord Justice Lewison was abundantly sure that there's no policy rationale to deny charity relief if it happened to buy a property in conjunction with another non-charitable person.
But just to confuse the issue, does it make any difference whether you've already rectified the pension legislation? I mean, in the absence of a rectification to the pension legislation, presumably you would already, at the point you enacted the HICPIC legislation, have had a situation where amounts on which individuals could be taxed would not have been within 29(1)(a). Now, supposing that to be what Parliament thought was appropriate in relation to pension legislation, well, why should one conclude that they didn't think the same was right in relation to the HICPIC?
The repetition of a glaring irrational error, in my respectful submission, does not entitle, I think, the court to be satisfied that the second time that occurs in identical form, that the second time it must be rational and therefore immune from an inco-Europe interpretation.
I mean, it would be quite coherent. Supposing that you haven't rectified the pension legislation so that amounts chargeable to tax were not susceptible to discovery assessments under 29(1)A, well, Parliament would be being consistent in achieving the same result in relation to Hickby.
Parliament is, if one's looking at Section 30 and all the separate provisions by which one can raise charges, it certainly, you can't infer, certainly from that the anomalies in relation to pensions and now Hickby were some sort of deliberate choice. And one can't really fathom, in the words of Lord Justice Lewison, any rational policy explanation for that. In other words, that one would bifurcate the recovery mechanisms for Hickby between Section 29, where a return has been filed, and the use of Section 8 and determinations, and ultimately possibly Section 29, where one hasn't. Despite the efforts of Mr. Wilkes' counsel and the upper tribunal, when one stands back, that in my respectful submission, there is no rational policy explanation for it.
Well,
one can find a way.
You say that, but of course, this rather brings us to the question of the relationship between the state and the system, doesn't it? Because if you look at matters entirely from the perspective of the state will always want to have maximum enforcement powers. And you can run the argument, well, no rational legislator would not give the state the maximum possible enforcement powers. But if you look at it from the perspective of the citizen might well say, well, I'm not entitled to be taxed until Parliament has said I'm to be taxed.
That often is an argument in relation to substantive tax charges. But there's no doubt that this Hickby does apply to Mr. Wilkes and everyone like
To be sure, but this is an enforcement mechanism. So why isn't the same rationale apply?
Because Parliament is, by incorporation of Hickby into self-assessment, has already brought enforcement powers on. The question is, in relation to just one scenario, has there just been a very clear slip-up by the draftsperson? How does one test that? One has to try and identify a rational policy as to why one would leave Hickby out of Section 29(1)A, leave it within Section 29(1)B. Whilst it's possible to identify a route by which the revenue could enforce, except there is a route, that of itself doesn't render that choice rational. It renders it at best bizarre, and in my respective submission, it is so irrational that one could be abundantly sure that Parliament would have, but for the slip, would have amended Section 29(1)A. After all, it'd just be a similar change to the one which was introduced into Section 7.
And this is very similar to the purpose of construction argument, or it has similarities. If the anomaly, by the time we've got to incur, we've argued it, the anomalies have not been sufficient to get you home on the purpose of construction, how can they be sufficient to get you home on INCO Europe, which is a much narrower
my lord,
remedy?
The question of anomalies, for example, does come up in Poland Estates, and that isn't enough to allow this court, to find a purposive argument in favour of the charities.
Well, also, earlier you made the point it's a different time frame. So
Yes,
your
true.
argument on purposive construction is based on the legislation as it existed in 1998, whereas this argument is all about the amendments in 2012. And what you say is there was an oversight in 2012. But you look at what the changes that were made by the Schedule 1 to the 2012 Act. Plainly, there was a simple oversight. It must have been intended that they would have amended Section 29(1)A as well.
Indeed, my lord. But there is a broader point, which is invariably the court is thrown back onto INCO Europe, where a purposive argument has failed, despite the clear anomalies being there. So that is almost a permanent feature of all of these cases, that the purposive argument has failed. I quite appreciate that I'm in a slightly different position than the revenue was in Poland Estates, because I'm dealing with actually two different legislative processes at different points in time. But that wider point also stands good.
Sorry, go on. Can I revert to my tangent one moment? So you've got the pensions legislation, which has come in earlier. On the face of it, it would be very difficult to apply an INCO argument to the Act itself. It would have to be applied to the regulations if there were scope for an INCO argument. And there we find in Regulation 9, page 133 of the bundle,
Yes.
Through the mechanism of the statutory instrument, specific provision has been made in relation to Section 29, but only in relation to cases 1, 2 and 3. And so they don't bite on an individual. So at that stage in 2005, it was not thought necessary or appropriate to amend Section 29 to catch the payment charges in relation to an individual. And it's jolly hard to see how on an INCO basis you go behind that, isn't it? I mean, if Parliament has specifically said, well, we're doing this for cases 1, 2 and 3, how can you say, well, actually, Parliament must have meant to do it for all of them?
I can see that where Parliament has made a very deliberate choice in terms of 1, 2 and 3, admittedly a choice made under a material misapprehension. You might say it's so obvious that they must have included case 5 as well for this reason. But to say actually what Parliament ought to have done is amend Section 29 1A in general terms. I agree that would be a difficult argument.
So come 2012, we've got a situation where there is no, I mean, subject to all your earlier arguments, amounts on which individuals are chargeable in the pensions context are not caught by Section 29 1A. Does that affect whether Parliament must be taken to, whether we can be abundantly sure that Parliament was making a mistake in achieving consistency when it passes the 2012 Act?
In my submission, no, my lord, because this is obviously dealing with a separate tax. Admittedly, the draftsman might have been under a mistake, but what we do have in relation to HICPIC is obviously Section 7 is amended for HICPIC, and the slip up to carry through that intention, i.e. the intention to make self-assessment work for HICPIC, just is frustrated by the failure to amend Section 29 1A. So it is a slightly different.
Just help me. So if you have the if you have a pension charge on an individual, does that not have to go into the self-assessment?
It does, but the way it's done is different. So if one goes to Section 7,
Regulation 7. Or,
yeah,
no,
sorry,
Section 7.
No, yeah, Section 7
of the TMA.
The provision I had in mind was actually section 9, which is on page 15.
Yeah.
There's a carve out from self-assessment in 1A in relation to certain pension charges, and that continues over the page. It does not exclude a 208. So what?
Well, sorry, can I just ask? This, what we're looking at page 15 is the version that was enforced from 2017 onwards.
Yes.
So is that relevant to, when we're considering the position as at 2012?
Yes, because I think 1A predates. Just have a look. Okay. If one turns to 55, you can see it as at 2009 to 2016. I don't think much is. So that 1A definitely does predate HICPIC, for example.
Thank you.
So the tax to be assessed doesn't include certain things.
Yeah, I agree. But that doesn't exclude, for example, an individual who's liable to the unauthorised payment charge. The issue is obviously for that, we know the payment isn't income for income tax purposes. So there has been no change to Section 7 in that regard.
So in relation to
But it would have to be on the return if you had notified, but it might not be a trigger for notification. I think is probably the position. I think that's right. Yeah, well, exactly. Yeah. The scheme administrator will obviously have separate reporting obligations to the revenue, which may be different. But certainly, when one has the pensions, when one has the Finance Act, Section 7, I don't think is amended in the way that it is amended under Finance Act 2012 in relation to that unauthorised payment charge. So it is if it is an error in relation to Section 29, it's certainly a different one, or other things went wrong as well, potentially.
yeah.
The argument really is, Parliament's gone to the trouble of amending Section 7 to make it very clear that HICPIC is going to fall within the notification of liability. It has to go into the return. There's no dispute about that. If you file a return and you don't include the charge, self-assess the charge, there's a very clear power under Section 29B to deal with that. Parliament, perhaps through oversight, did appreciate that Section 29(1)A wouldn't apply if you didn't file the return. Is there any policy rationale for that whatsoever? In my respectful position, no. The fact that there is a workaround using Section 8 and other powers, in my respectful submission, can't be considered to be a rational choice by Parliament. The fact that a workaround does exist isn't a basis for saying that Parliament has made that choice, certainly not consciously. But why would that workaround? What is the benefit to the taxpayer for that? What is the, just picking up the words of Lord Justice Arnold, in relation between the individual and the state, what is the policy rationale for going down that route in circumstances where all roads will lead to Rome, in terms of an assessment somewhere at the end of the day. Those are, I mean, just turning to the points made by my learned friends are that there's no obvious drafting error. Well, I think I've been over that at least twice. There's the extending the revenues assessment powers. I mean, I accept it is an extension, but it is an extension which one must have thought would apply, and there are already revenue assessment powers under Section 29. The wrong sort of error that I've already dealt with by reference to SFO. There's one more argument, which is we can't be abundantly sure which choice Parliament would have gone down to remedy the error, and that's what's really set out in my learned friend skeleton at paragraph 79. Uh, 79B. That's at page 74 of the core bundle. There are broadly three different approaches adopted in relation to assessment of Step 7 income tax. The one is treatment as a charge on income. Well, we can be sure that Parliament would have done that because that simply is not what Parliament has done in the main body of the legislation for HICPIC. The second is an imposition of a special regime, standalone power by statute, so a separate assessing power. But why on earth would Parliament do that in circumstances where HICPIC has already got one leg in Section 29 in terms of 1B, why would Parliament create a whole special regime just to cater with a deficiency in relation to 1A? My respectful submission that would be absurd. And the third one, a conferral on powers on the revenue to make regulations, as in fact obviously happened under the pensions regulations. But again, why on earth would Parliament do that where only one word in one section needed to be amended? One phrase. And in circumstances where the 29(1)B power already exists. So, yes, there are different mechanisms by which Parliament could have fixed this. None of those, in my respectful submission, would, the mere possibility that one could have gone down those different routes does not, in my respectful submission, given they would have all have been very odd choices for Parliament to make. None of that detracts from the fact that you can be abundantly sure of what Parliament would have done in relation to FA 2012. So, in my respectful position, that's not that won't bar the revenue under Inco Europe either. I entirely accept, this kind of case compared to some of the others is novel in that it's an extension of a revenue power rather than, for example, the creation of a bus tariff over a bridge or tweaking legislation to stop powers of appeal going, or an extension of an exemption which otherwise wouldn't have existed for charities under SDLT legislation. But each new case will obviously create new facts and circumstances. And the question which this court has to answer is, are the criteria in Inco Europe satisfied? And if they are, is there any other reason why, for example, we wouldn't read in this power? But there's one last point, which my learned friend raises, which is if one goes back to Inco Europe itself, and the passage I took you to, this is page 277. This is by H, where Lord Nichols continues, sometimes even when these conditions are met, the court may find itself inhibited from interpreting the statutory provision in accordance with what it is satisfied was the underlying intention of Parliament. The alteration in language may be too far-reaching, and the insertion must not be too big or too much at variance with the language used in the legislature. So I accept you are going to have to put in the review's invitation a separate provision dealing with section 29(1)A, which really will carry over the change from section 7. I appreciate that's reading more words in than to the extent that, for example, in Pollen.
So just thinking it through for one moment.
Yep.
For Inco purposes, well, could we turn up what Parliament has now done?
Yes.
Tab 35 in the authorities bundle. So is it your case that in construing the 2012 Act, we can be abundantly sure that Parliament meant, so to speak, to make the amendment that we see in section 95(1)?
No, because that goes far wider than the fix for the HICPIC.
So the gist of the change would be what?
The gist of the change, if one turns back to section 29, obviously the version we have here has got all the inserts,
Yes,
which
which is
only for cases 1, 2, and 3.
yes.
But it would be essentially inserting something else. There are two ways you could potentially do it. Namely, after any income, one could add any high income child benefit charge. So that then reads any high income child benefit charge which ought to have been assessed to income tax. Now, that might meet the objection of, well, it's not the charge which is assessed to tax. The charge is itself a charge to tax. That was certainly a point, I think, made in a different context by the upper tribunal below in relation to the to Schedule 18. We don't accept that's right. I think it would be tolerably clear that that's what Parliament would have intended. But if, insofar as it doesn't work, you would just add a new subsection, i.e., in addition to A, B, and C, maybe a double A, any liability to high income child benefit charge has not been assessed.
Just give me that wording again.
That any liability to the high income child benefit charge has not been assessed. Obviously, and I think this is common ground, you don't have to be abundantly sure of the precise wording that Parliament would have used.
No.
But you do have to be sure as to the effect of that wording.
So just so the supposed little a would say that any liability to ICBC has not been assessed. Yes, I see.
Unless I can assist you further, that's the remedies case on those 3 points.
Thank you very much, Mr. Yates. Yeah, Mr. Mallet.
Good afternoon, my lords. That clock isn't working. I think I'd have 15 minutes before the shorter journey. I don't know whether that might be sufficient or whether it would be easier to start and do it in one piece afterwards.
I think I would be minded either to come back at 10 to 2. Maybe that's a convenient course. So let's rise now and we'll start again at 10 to 2.